We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, thank you very much and good morning. Welcome to today's remote sitting of the Appeals Court. My name is Ariane Buno. I'm joined today by Justices Greg Massing and Kenneth Desmond. We'll be hearing your case today and all the cases that are on schedule for this morning. Just a brief reminder, you each have 15 minutes to present your argument to us. There is no rebuttal in the Appeals Court. And upon occasion, but let's not jinx ourselves, we do experience some technical difficulties. And if that happens, just be patient. Any glitch is generally resolved fairly quickly, and someone will contact you and we'll get to the bottom of it. And I can assure you that neither one of you will lose any time if anything like that happens, okay? So I'm gonna call the first case, Commonwealth versus Stephen Flood, number 2020-0277. Attorney Reedy.
Good morning, Your Honors. My name is James Reedy, and I represent the appellant, Stephen Flood. Mr. Flood filed a motion for new trial alleging serious deficiencies in his counsel's performance in the trial court. He also filed a motion for post-trial discovery seeking clearly relevant and exculpatory information that defense counsel chose not to request from the Commonwealth. The trial court erroneously denied the motion for post-trial discovery and refused to hold an evidentiary hearing on the motion for new trial. This requires a remand to the trial court for allowance of the motion for post-trial discovery, as well as an evidentiary hearing on the motion for new trial. The first major misstep of counsel concerns joinder of the cases for trial. Prior to trial, the defendant was indicted on two separate indictments. One for sexual assault of JL, and then a separate indictment alleging two sexual assaults or two assaults of victims, JG and AW.
So, Attorney Reedy, just so I'm clear, the appeal is for the denial of a hearing relative to the motion for new trial and to the denial for the post-trial discovery. You're not making a claim of ineffective assistance of counsel. Is that fair to say?
I am making a claim of ineffective assistance of counsel relative to that encompasses the denial of the motion for post-trial discovery as well as the denial of the evidentiary hearing. I'd suggest that I can't ask for an allowance of the motion for new trial because there are questions that are open that would be necessary for an evidentiary hearing to resolve. But to the extent that that motion, the motion for new trial, as well as the motion for post-trial discovery, essentially involves a claim of ineffective assistance of counsel, I think there's at least some question this court must answer relative to that claim in order to determine whether Mr. Flood met or overcame the hurdle for both the motion for post-trial discovery as well as for the evidentiary hearing for the motion for new trial.
So standing alone, you're not making a claim for ineffective assistance of counsel?
I'm not making a claim that this court is required to make a ruling on whether Mr. Flood's attorney provided ineffective assistance of counsel. What I'm requesting is whether we met the hurdle so that to at least raise the serious issue that there was an ineffective assistance of counsel claim such that an evidentiary hearing should have been held and that the motion for post-trial discovery should have been allowed.
Well, what exactly do you expect to present or to learn from an evidentiary hearing in this case?
Well, I think there's open questions relative to why trial counsel, and I'll start with the issue of joinder, made the choice after successfully opposing joinder to move to join the cases.
Didn't he address that in his affidavit?
Well, he addressed a couple of different things. One, he said, well, I was
zeroing in on this though, didn't he say in the affidavit why he made that strategic decision? I.e. that it was likely that Judge Agostini was going to allow the Commonwealth's motion to introduce the evidence with respect to the sexual assault of one of the victims in the trial of the other.
So that raises the issue though. So first, trial counsel says, it files the motion to oppose joinder and says, look, these cases are not a pattern of conduct. They don't share the commonality for joinder under Rule 9, to which Judge Kinder agreed with him and said, you're right, they don't share the same pattern of conduct.
Did he say that or did he defer to the trial judge?
He deferred to the trial judge relative to whether the evidence would be admissible as prior bad acts. But I would suggest that that ruling determination that there was not a commonality between the charges eliminated pattern of conduct. It doesn't then, just because pattern of conduct is out, there are other reasons why prior bad acts may be admissible. And I think Judge Kinder wisely said, while I don't believe that these reached pattern of conduct, I am not going to step in and make a preliminary ruling prior to trial that these cases are just blanket inadmissible for purposes of prior bad acts, where I don't know and I can't foresee how this may play out at trial. If the defendant raises an issue of intent, if the defendant raises an issue of mistake, I am not going to tell the Commonwealth at this point in time that they are unable to counter those claims by defense by refusing to allow them to admit a prior bad act. But I would suggest, based on the ruling that they are not common under Rule 9, that at least as far as pattern of conduct was concerned, that was off the table. But to get back to Justice Vona's question about what would be raised, so one of the issues that the trial counsel also raised is he said, look, admission of these as prior bad acts is inherently and highly prejudicial to the defendant because it raises propensity issues. So we have trial counsel at one instance saying, I do not want to try these cases together. I am opposing the Commonwealth's motion for joinder because I do not want to try these cases at the same time. He then says, well, now I want to try the cases at the same time. And remember,
well, not exactly, because there was a substantial change in the situation of the trial, because the trial judge indicated that it was more than likely that he was going to allow the Commonwealth's motion. So yes, at that point, at that point, the issue was revisited by trial counsel. And don't we have to determine whether or not that revisitation, so to speak, and change in strategy, which was, he indicates, was based on the fact that it was better to have one trial than have two. Was that reasonable? Is that the question we have to ask? If that was a reasonable? So
I'd suggest there's two issues there. First, there was no determination that these would be admissible as prior bad acts. Counsel may have decided that he was foreseeing what the court may have done, but as this court previously determined, there was no decision by the trial court for prior bad acts. All the trial court said was, I need to research the issue. I'm inclined at this point,
and I'm likely to allow the motion. I'm likely to allow the motion, as I recall.
It's what he said, but as this court has previously said, that's not a decision. So to say so the change in circumstances, I would suggest didn't take effect yet because there was no decision. Okay. If there had been a decision, I might be in a different stance, but there was no decision.
And secondly, I was going to stop there. In his affidavit, he says something about they hadn't completed discovery on the second set of cases. Correct. Did the agreement to try them all together get him more time before the next cases?
The trial court said during the course of the hearing, look, if I'm going to allow this motion, I will give you more time. So the timing issue wasn't dependent upon the defense counsel's decision relative to joinder. He was getting more time regardless, whether the court was allowing the motion was allowing the prior bad acts motion. If the court was to allow the prior bad acts motion, he was getting it. He was getting that time. He didn't need to request joinder in order to get that time. But I would also suggest, into the second part of my answer to Justice Wona's question, even if that this was a strategic decision that an ordinary trial counsel would make, trial counsel then followed it up during the course of trial by not making any request to have any instruction that would preclude the jury from using evidence of each sexual assault as evidence against the other. Let's remember, at trial, there was only one quote unquote prior bad act that was used, and that was concerning uncharged conduct relative to JL. And that's the only instruction the court provided relative to an instruction to prevent the jury from considering the evidence. There was nothing relative to the charges of each individual defendant. And because there wasn't each individual complainant, and because there was not an instruction relative to each of the charges, the jury was free to use the evidence to determine that Mr. Flood had a propensity to commit the crimes alleged. The
Was there a
Commonwealth
request
suggested
for an instruction?
there was not, which is housing the ineffective assistance, which is part of the original ineffective assistance to counsel claim. And it's not as if trial counsel wasn't alerted to the issue. As I previously mentioned, in his motion opposing joinder, he said, look, this is highly prejudicial because it could be used for propensity. So despite that, he never followed that up at trial, never asked the court for an instruction for the prior bad acts to preclude the jury from using evidence of one relative to the other. The jury was free to use it as whatever they wanted. The Commonwealth encouraged them in closing argument to consider the three cases as one whole, suggesting these are three different men united. If you believe the three of them, that's all the evidence you need. So the jury was left with this idea of like, well, we've got three different people making allegations, and they could use one as evidence of the other. And the only evidence for each individual sexual assault essentially was the credibility of each individual complainant. There was not a lot of evidence at this trial. There was the evidence of each complainant, and there was some first complaint witnesses, and that's it. And so in that circumstance, to have three separate criminal charges, three separate complainants with no instruction to the jury as to how they are to use that evidence when considering it in the entirety of the whole, raises an issue of ineffective assistance to counsel for which there should have been an evidentiary hearing. It's hard to say that based on the trial counsel knowing that there was an issue with propensity, ignoring that during the course of trial, that somehow that was not ineffective assistance to counsel. And certainly I'd suggest there needs to be an evidentiary hearing relative to the trial counsel's affidavit. I would also suggest.
So basically, essentially you're saying you want to use just one moment. I know it's hard on Zoom to see when someone else is about to ask something. So we're patient. We understand that. We've been doing this since September, so we know. But let me interrupt you for a second. So essentially what I'm hearing is that you want trial counsel to be on the stand and to be cross-examined on the decision that was made to not oppose joinder, or to agree with joinder. Is that right?
That's correct. And I would also suggest, while the case law is not entirely clear, I think the suggestion is that a motion for new trial, if there's an evidentiary question, cannot be allowed without an evidentiary hearing. I think he'd be denied without an evidentiary hearing, and obviously I think that's error here. But I don't think that Rule 30 allows for a motion for new trial where there's evidentiary questions to be granted.
When you conduct that cross-examination, you're of the opinion that you will receive additional information that's not included in the affidavit.
I'm of the opinion that I will receive additional information that's not included in the affidavit, but I am also of the opinion that there's an open enough question that an evidentiary hearing is required, because Rule 30 does not allow for a motion for new trial to be granted with open evidentiary questions. And I'm assuming the Commonwealth has some questions relative to why defense counsel did what he did. I mean, I certainly think there's a question as to why defense counsel made a determination that having these cases all tried at once would be highly prejudicial, but then decided that, well, I guess it's not highly prejudicial if I'm joining them together.
Well, I thought he answered that question in some respects, because one, he thought that evidence of the other matters was going to come in each trial. And rather than having the Commonwealth have an opportunity to learn from trial to trial and shore up its case, he had a better chance of trying to attack it all in one trial, where maybe the footing wasn't so sure. So that sounded like a strategic decision, whether you agreed with it or not.
Well, I think that if trial counsel then went forward, two things. One, by doing that, trial counsel essentially waived any argument that this wasn't a pattern of conduct, because he essentially asserted it is a pattern of conduct because I'm agreeing that these cases are joined together as common instances for trial. Secondly, I would suggest that if that was a strategic decision, that the wisdom of that decision in the extent to which trial counsel was making a reasoned strategic decision is belied by the fact that he then decided that I'm not even going to ask for curative instruction or a limiting instruction relative to how these issues are tried together. I'm not quite sure that based on trial counsel's affidavit, he had an appreciation for what he was doing. He had an appreciation for what joinder meant, and he had an appreciation for strategically how he was going to approve a trial. If he then goes into trial
Well, just
and
a minute
allows
there,
for an
because,
evidentiary free-for-all.
of course, apparently the trial judge who wrote a comprehensive memorandum of decision, he determined that trial counsel knew exactly what he was doing and made a reasonable decision. And so we have to look at what the trial judge determined under the standard of abuse of discretion. So I quibble a little bit with your comment that you're not sure what was going on in trial counsel's mind. Yes, of course you can't get inside his mind, but the trial judge was there and he saw the whole trial and decided something different.
He did decide something different, but I would suggest that to make a determination that trial counsel has an appreciation for the prejudice of the prejudicial effect of having these cases tried together, and to say, well, it's a reasonable strategic decision, he knew what he was doing, is then belied by the fact that when he went to trial, he took no steps to eliminate the prejudicial effect of trying these cases together.
I think we have that. I have that. You only have about 10 seconds left, and I don't want to cut you short with respect to your issue on a discovery issue. But you have about 5 seconds if you have anything.
Let me just make one pitch. The evidence is out there. If the Commonwealth agrees, it should have been turned over. The counsel should have asked for it. The ADA's statement isn't enough to get us into whether it was a denial, failure to turn over exculpatory information. She provided enough. It's significant. It relates to the credibility. Post-trial discovery should have been allowed.
Okay.
Thank you.
Thank you. But before you finish, I'm going to check with my panel, with the panel, to see whether or not there's any further questions, anything else that they would like to probe before you.
Just to clarify, the discovery that you want is the efforts that the Commonwealth made to locate the therapist.
That the police reports, presuming they're there, considering it was a quote unquote months-long investigation. The photo arrays that they conducted, they said they got arrays of every single woman who worked in the emergency room department. So anything related to their efforts relative to the identification of that individual.
So that's a yes. The efforts that they made to try to find the therapist whom the first complaint was allegedly made to.
That is a yes.
All right.
All right. Thank you very much. Any further questions, Justice Desmond or Massing? No? Okay. All right. Great. I'm going to turn it now over to Attorney Baker.
Good morning. May it please the court. Assistant District Attorney Lee Baker for the Commonwealth. So I want to talk a little bit about the change of circumstances between Judge Kinder's original ruling denying the Commonwealth's motion for joinder, and then Judge Agostini's inclination to allow this evidence to come in at trial on the indictment, the 240 indictment relating to JL. The change in circumstance was not limited to a different judge with a different ruling. In fact, the state of the evidence had changed. And I think that that is really important in assessing this claim. If I will refer the court to the defendant's record appendix on pages 147 through 148. Now, that's where they're discussing the motion eliminate to admit this bad acts evidence. And what you find is they're there for the indictment on the charges related to the victim JL. And the trial prosecutor had disclosed that day to the defense attorney that more information had come out from JL in preparation for trial, particularly around the swimming pool incident. And what you find out is that JL had elaborated on this incident. He'd made mention of it in the grand jury. It wasn't charged conduct. There was an indictment related to that. He'd made a passing reference to having been abused in the pool. When he was preparing for trial, he went more in depth into it. And that's where he discussed being teased by the defendant. We're all adults here. And this is really important because that's where you get the theory of a common course of conduct now really blooms. When it was before Judge Kinder, the only thing you had was this passing reference in the grand jury to there having been abuse at the pool. Now, when they're before Judge Agostini and they're at the eve of trial, there's this new further information that has developed from the complaining witness, JL, that gives details that really resonate with the claims made of the other victims around teasing, use of language like we're all men here, pressuring the victims to engage in this conduct based on that kind of rationale. So what I would say is that what defense counsel is recognizing at this hearing when he has this new information is that this is a different set of evidence than what was before Judge Kinder. And now it's a much stronger claim for a course of conduct. So it's not just that now I have a different judge who's going to rule differently than Judge Kinder did. The sands have shifted beneath our feet. This is going to be a different trial, even if the testimony from the other victims doesn't come in. Now there's going to be additional stuff that we're going to hear. And that may mean that that information will come in at the subsequent trial. So now the state of the evidence has completely changed. Now his whole method of cross-examining that victim in that trial will have to be revised. So it becomes, I would say, an eminently reasonable decision at that point, reading the tea leaves from Judge Agostini saying, I'm very likely to allow this, looking at the fact, well, this is different evidence. It's a sound tactical decision that I would say that many defense attorneys of ordinary training would have made.
Let's say that's true. Why no request for a limiting instruction once the trial got underway?
Well, that's a fair question. I mean, it would certainly have been better to have made that request. But I would say, and there's language in Pillai, the case that I cite in my brief involving the common course of conduct evidence, that suggests also that, that's the better practice. Now, whether it's ineffective, I would say it's not, because as in Pillai, there wasn't really prejudice, and especially because contrary to opposing counsel's argument that it was an evidentiary free-for-all and there was no instruction to the jury that limited their use of the evidence, there was in fact some limiting of the evidence through the judge's instruction at the final charge, where he gave a instruction, I'm just grabbing the exact language here, where he said that the jury had to consider the fact that these were separate crimes, separate allegations, and that the evidence had to all be considered separately. And he uses that phraseology over and over again, separately, and really drives home clearly that you have to look at each of these indictments separately and their evidence separately. So while it would have been a better practice to have him elaborate on that considering it separately means that you can't consider the evidence from the one as propensity for the other. That would have been a better practice, but I don't think that on these facts, the defendant was prejudiced by the lack of that limiting instruction, or that it's really fair to say that it was an evidentiary free-for-all and that they had no sense that their evidence had to be considered relative to each particular indictment alone. And now, as far as the denial of an evidentiary hearing, I'm hearing that, we could have heard from trial counsel and he could have been cross-examined and developed more about, this ineffective claim, but I don't see what that line of cross-examination would be. What even hypothetically the trial attorney would say, inconsistent with what is already stated in his affidavit and is in the record, that would bolster this claim of ineffective assistance to counsel. It's unlikely that there's going to be, on cross-examination, he's going to suddenly say, "You got me, I just got scared and made an irrational decision."
Right.
So respectfully, I don't really see what we would have gotten out of an evidentiary hearing. And as far as the post-trial discovery goes, now, the two concerns there is, one, assuming that all of this still exists, that the arrays are still there, that reports were authored and could be produced. I have to say, I don't know one way or another whether that's the case, but assuming it is, again, what would be their purpose? This information's value as a defense would be impeachment, right? To challenge the credibility of the complaining witness, to suggest that they fabricate, that they, as was suggested in the defendant's brief, that it was a hallucination or a fabrication.
Wasn't there a contemporaneous note in one of the records?
Exactly, there is that which sort of belies that claim. And furthermore, even if that wasn't there, how would having the photo arrays or the police reports improve on that impeachment? All of that can be done. The information was disclosed thoroughly at the hearing. All of that is known. Having those objects, those tangible objects, wouldn't really do anything to further that defense. So the denial of that motion doesn't really preclude mounting that defense if in fact there were a new trial. It would really sort of be extraneous. None of it would come in substantively. It's irrelevant.
Can I ask you about the, in fact, when that witness testified, he never testified about disclosing to the psychiatrist first, right?
Right, because of course, there was a motion to have a replacement first complaint witness, which was the sister. And so once you have this replacement first complaint witness, you can't get into that at all.
There's something in defense counsel's affidavit that said the judge instructed him not to ask about that. Is that the case?
I don't recall, but that may be the case. I think that would be correct in so far as you can't really, I mean, the case law does say the first complaint limits the Commonwealth, not the defendant. So if he really wanted to go down that road, he could. It's a perilous road, but
he says that the judge told him he couldn't. In his affidavit, he says that.
Says that he couldn't get into. Yeah.
I mean, did that happen in the trial?
I honestly don't recall.
Okay.
I apologize.
It's okay.
So on those narrow issues of whether or not there should have been an evidentiary hearing or whether the post-trial discovery should have been done, that's really all I have on my brief. If you have any further questions.
I'll check with the panel. Justice Massing or Desmond, do you have any additional questions for the Assistant District Attorney?
No, thank you.
No? Okay. All right. I think we're